Now, what does it mean as a practical matter that this has been eliminated? It means that people won't even be tested for HIV. And so it should be really an invisible issue. You know, in the past, when people have applied for permanent residence, they have, and still today, people have to undergo a medical evaluation. And that evaluation consists of things like a blood test, and a skin test for tuberculosis, and a series of questions about their health history. And it has included, the blood has been tested for HIV. That will no longer happen. So that if a person has HIV, it shouldn't even be known to the immigration examiner unless the person was to raise it themselves or were somehow to come out in the facts of the case. So it should just be really, it should revert to being a private personal issue that's not something that should be inquired about or should even come up in an immigration case. And certainly people who are trying to come here temporarily will no longer be asked if they're HIV positive. And so it should not be a problem for people who are trying to visit the United States. You may know that this has also been a big problem where people were trying to come here temporarily, either on non-immigrant visas, and Richard's going to go through all those categories, or simply coming for a visit. In recent years, those visits have been limited to very short periods of time. People had to go through jump through all kinds of hoops, showing that they had already sufficient medical treatment. They weren't going to need anything when they came to the U.S., and their stay was very limited, or often limited to a period of 30 days. All of that should go away, and someone who's HIV positive and wants to come here, say, as a student or as a visitor, should be able to just come as if they had never had HIV, and it should be a non-inquiry and a non-issue, and they shouldn't be limited. It's subject to any additional time limits that wouldn't go to any person in that particular category. So that's great. So the same is true if you know someone who's outside the country, say, who wanted to come here in the past as a visitor, or maybe had a temporary job offer and were denied because of their HIV status. That's another type of person who should consider reapplying now that that's gone away as an issue. Now, so given that's gone away, the first International AIDS Conference is now planned to happen in the United States in 15 years because it hasn't happened in the past 15 years because of this issue and because of a boycott, you know, essentially as a protest to the U.S. government excluding people who had HIV. And the Immigration Service has announced, and in fact you had in the materials that you picked up when you came in at the desk, you have a little memo from Immigration which indicates how they're going to handle cases in future. It's just about 4 pages long, and it's saying that if a person was recently denied a benefit because of their HIV status, they will accept motions to reopen even if they are, if they've exceeded the deadline. Normally a motion to reopen has to be filed within a 30-day period. But if they were denied after this date, July 2nd, 2009, so if you know someone who recently had this problem, Immigration has said they'll reopen that case. They do have to pay a fee to have it reopened, which is $545, I think, so it's not free, but it's cheaper than refiling the case, and if that was the only issue, it should be a solution. So that's very important to know, that recently denied cases could be reopened. If someone was denied, say, a year ago, or 2 years ago, or 3 years ago, it's going to be too late to reopen the case. They will have to reapply, which means new filing fees, but they should be able to reapply with this being a non-issue and not be prejudiced by the fact that the case was denied in the past. Now, we have the bottom line here. We had some concern that if someone had been, say, denied in the past because they were HIV positive, that in a new case, that could turn into what we call the public charge problem. That is, that immigration could question whether this person could really support themselves, or whether they were going to rely on public benefits because they had HIV. Now, there's no, it's something simply to be aware of and to be cautious about. There's no indication in the memo that you have as part of your packet that's come from immigration that they intend to do that, and it really does seem from the memo that's been issued by immigration headquarters to officers in the field that they do have good faith intention, and they don't intend to basically use HIV to cause another type of problem, public charge problem. There's no indication they intend to do that. But everybody who immigrates to the United States does have to show either that they can support themselves or that they have a relative who can support themselves. So if you had a person who had HIV and was really sick and unable to work for that reason, it would be necessary to show that someone was able to support them. Now, if they are receiving assistance, say medical assistance or medication, say through the HDAP program, that should not be a problem in future immigration cases. That even wasn't a problem in the past with HIV waiver cases. So it's not, it's certainly, it's just really a note of caution, something to be aware of, and that lawyers in future or providers who prepare these cases for people going forward will have to be sure that that issue of financial support is documented. But we don't, at this point, we don't anticipate that that's going to be a problem. And HIV can also be an important factor in asylum cases and also hardship waivers. So this is, for example, if a person is is in deportation proceedings or fears being sent back to a country where they feel that they will be persecuted. If they have HIV, that can be an addition. That is normally not enough of a reason to gain a loan to gain asylum. But say there were other reasons, maybe they were gay, or they were in a political organization that was being persecuted by the government in that country. The fact that they also have HIV could be a helping factor, actually, in that immigration case, because it would tend to indicate that the suffering that the person would experience, say if they were going back to a country where they would have difficulty accessing treatment, that the conditions for them and the amount that they would suffer would be heightened by virtue of the fact that they have HIV. So that this is unchanged. This we have been able to use, even when HIV was a ground of inadmissibility, it can sometimes be a factor that someone would want to raise in an immigration case if they felt it would make the case stronger. But the good thing about this is now that it's been removed as a ground of inadmissibility, it will essentially revert to the individual of whether they want to voluntarily bring this out as something to strengthen their case, rather than something that they're forced to disclose in the required medical evaluation or on a form that they have to fill out when they're trying to come to the United States. So